You paid thousands for your wedding photos, and your photographer says you can't even print them?
That's right. Welcome to copyright law, sprinkled with pixie dust and panic.
This is the BrideLawyer Podcast, where fairy tales meet the fine print.
I'm Shari Morgan, an attorney for 38 years and co-founder of BrideLawyer.
And I'm her daughter, Morgan Weil, lawyer, newlywed, and proud owner of about 1,200 wedding photos I technically don't own.
Today's episode, Snow White and the 7 Watermarks.
A story about a bride we'll call Snowy, who thought she bought her happily ever after until the fine print showed up with a copyright symbol. Snowy wasn't a princess. She was a graphic designer, practical, creative, and the kind who color codes her inbox. She booked her dream photographer, signed the contract, and didn't think twice.
Because who needs to read the fine print when you're suddenly surrounded by tulle, timelines, and talking birds?
Exactly. Her wedding day was magic. Months later, though, her digital gallery goes live. Stunning. Like a storybook come to life. But when she tried to print enlargements for her family, a watermark appeared on every single photo.
I remember she called the photographer and he said, "Oh, the gallery's just for viewing. You didn't buy the usage rights." Then he wanted another $1,000.
She was stunned. I paid him so much already. It's my face, my guests, my wedding. How can I not own my own pictures?
She called us, sounding more dopey than Snow White. And she's a graphic designer. You'd think she'd know.
Don't be harsh. Most people don't. You're paying for art and emotion, not thinking about Section 106 of the Copyright Act.
That's true. But the truth is, photographers automatically own their work unless you negotiate otherwise.
And like so many brides and so many business owners, she didn't realize she wandered into a forest of fine print. Snowy's photographer owned all the rights to every single image. What she actually bought were 2 physical albums, nothing more. She couldn't legally download, crop, or print anything else.
Which is unusual these days. Most pros give clients personal use rights. You just can't alter, resell, or use them commercially.
Meanwhile, he was posting her portraits all over social media for ads, promos, even a bridal show banner, perfectly allowed under the release she signed.
So she became the fairest stock photo of them all.
And she paid him for the privilege.
The silver lining? We helped her renegotiate a new deal. A lifetime personal use license. No royalties, no approvals, no strings attached.
And he kept limited commercial rights for his portfolio, a happily ever after where everyone got to keep their mirror.
Let's meet the 7 little clauses that caused all the trouble. Snowy's 7 watermarks. Number 1, DOC, the knowledge clause. The photographer automatically owns the copyright. Payment doesn't transfer ownership unless it's in writing.
Number 2, Grumpy, the limited license. That sweet line about personal online use only, it means no filters, no crop, no business posts, even influencer posts that earn you a free candle equals commercial use.
It's true. Number 3, Sleepy, the model release. You may sign half awake, but this clause lets the photographer use your image anywhere, websites, portfolios, and probably permits guest spaces too, which legally it really can't do. Guests have to give their own consent.
4, Bashful, the social media clause. Some contracts require you to tag or credit the photographer or even ban you from posting altogether until they approve your caption. Bashful indeed.
Number 5, Sneezy, the everyone's doing it myth. Just because everyone posts doesn't mean it's legal. Copyright is still the law. It just naps quietly until someone wakes it up with a lawsuit.
Number 6, happy, the fix. Ask for a broad personal use license, or if you'll use the photos for work or marketing, a commercial license. Easy, inexpensive, forever.
Number 7, dopey, my favorite. The don't sign without reading rule. Never sign a contract you don't understand, no matter how sparkly the font or how charming the photographer.
And just like that, Snowy's 7 watermarks became 7 lessons in protecting your memories. Whether it's wedding photos, engagement shoots, or business headshots, here's how to stay in control of your images.
1, ask exactly what you can do. Print, post, edit, get it in writing.
2, for true freedom, ask for a lifetime license, usually a modest add-on fee.
Number 3, confirm whether your photographer can use your images for ads or awards. If not, cross it out before you're signing.
4, need them for your brand or business? That's a commercial license. Different rules, still affordable.
And 5, remember, credit is polite, but it's not ownership. You can thank them publicly and still protect yourself privately. In the end, Snowy got her photos, her prints, and her peace of mind.
And her story became the fairest of them all because she learned that even happily ever after needs a good lawyer and better paperwork.
Your memories deserve protection, not permission slips.
So before you smile for the camera, make sure your reflection doesn't come with restrictions.
And remember, true beauty may fade, but clear contracts are timeless.
So your photos are perfect, but what happens when the party isn't?
When the dance floor turns sick, the shrimp turns questionable, and Uncle Tony turns a little bit too friendly with the bridesmaids.
Or when the band keeps playing while someone's calling 911.
Because sometimes happily ever after needs a liability clause.
Next week, we're talking to you about the night the magic slipped.
The episode where champagne meets chaos, and we explain how to keep the fairy tale from turning into a claim file.
We'll talk spills, slips, food fails, bad bartenders, and what happens when the coach turns back into a pumpkin with paperwork.
Until then, I'm Shari Rifkin.
And I'm Morgan Weil.
And this is the BrideLawyer Podcast, where fairy tales meet the fine print.